So Megan Blake has a degree in law and a PhD in hermeneutics and interpretation. She has worked in policy research and project management and has taught at school and university. Megan's advocacy work has focused on women's rights and refugee support. She's currently working with the Feminist Legal Clinic and groups including Sex-Based Rights Australia and on the WDI UN Working Group, a sort of key member. So thank you so much, Megan, for coming to explain this, and over to you.
On the 6th of December, WDI emailed members of the CEDAW committee regarding its upcoming consideration of General Recommendation 41 on, it says, gender stereotypes. So we asked that it return to the language of sex and sex role stereotyping as found in CEDAW itself, rather than the language of gender. So this echoes Article 1 of the WDI Declaration that the rights of women are based upon the category of sex. So in talking about this, I'm going to cover some of the same ground as I did in November when talking about the Office of the Prosecutor developing its new policy on gender persecution. So the CEDAW General Recommendation 41 on gender stereotypes has been a few years in the making, and it's slated for discussion in 2025 and 2026. So the committee agreed at its 81st session in February 2022 to start elaboration of GR41 on the impact of gender stereotypes on the enjoyment of the rights enshrined in the CEDAW Convention, and it published a concept note of 20 pages on its principles, language, and content. A half day of general discussion on that concept note has been scheduled for the 17th of February this year, organised by the Office of the High Commissioner for Human Rights as part of CEDAW's 90th session in Geneva. The concept note names GR41 the General Recommendation on Gender Stereotypes. It lumps together a reference to, quote, sex or gender, or sex-based and gender-based roles or stereotypes 5 times in 20 pages. So it puts them together, sex and gender, 5 times. It refers to the two sexes using that word twice, and it does refer to sex role stereotypes twice. However, it refers exclusively to gender stereotypes 161 times in 20 pages, including in the title of the recommendation and in its definitions discussion. So I think we can conclusively say that it has replaced the language of sex with the language of gender, occasionally, so 5 times, lumping them together as though they're two separate but related concepts. The problem is the rest of the time gender is used, it's as though it's synonymous with the phrase sex role. Only this is never actually spelt out, and it's never explained why both are used sometimes, as in sex or gender, if they are in fact synonymous. Or if they're not synonymous, then what is the difference? Or how does the usage of them interact with the definitions of gender, such as that given in the Rome Statute? This is, of course, by now par for the course. So the term gender was used in international law prior to the Rome Statute, but the Rome Statute, I believe, was the first UN document to actually define the term. So the Rome Statute was written in 1998 and it came into force in 2002. It established 4 key international crimes, including crimes against humanity, and it also established the International Criminal Court. So its definition of gender was the deliberate result of what we call constructive ambiguity. So constructive ambiguity is a diplomatic use of deliberately ambiguous words to give comfort to parties on different sides of a debate in order to promote agreement and get them all to sign the thing, but without expressly giving either party the outcome they want at the expense of the other. So that's how the Rome Statute arrived at its definition of gender. So the Rome Statute defines gender in this way. It says, for the purposes of this statute, It is understood that the term gender refers to the two sexes, male and female, within the context of society. So it's talking about the social existence or experience or construction of sex, not sex itself. But it doesn't say that in really clear, unambiguous terms. The statute doesn't list sex as a separate ground, but in 2014, the Office of the Prosecutor Policy for the implementation of the Rome Statute, itself based on the WHO's definitions, describes sex as the biological and physiological characteristics that define men and women. The policy paper then defines gender as the socially constructed roles, behaviours, activities, and attributes that a given society considers appropriate for men and women. And it explains it really clearly. It says, to put it another way, male and female are sex categories, while masculine and feminine are gender categories. Aspects of sex will not vary substantially between different human societies, while aspects of gender may vary greatly. So there's no one agreed definition of sex versus gender across the whole of the United Nations, but these ones are the most commonly repeated ones or versions thereof. UN Women, for instance, defines gender as the social attributes and opportunities associated with being male and female, and the relationships between women and men and girls and boys, as well as the relations between women and those between men. It does this, but it still posts in support of trans lesbians on International Lesbian Day. In General Recommendation number 28 from 2010, the CEDAW committee itself says that sex refers to biological differences between men and women, while gender refers to socially constructed identities, attributes, and roles for women and men, and society's social and cultural meaning for these biological differences. And that this results in hierarchical relationships between women and men, and in the distribution of power and rights favouring men and disadvantaging women. So, two main problems arise here. The first one, the usage of gender in UN documents like GR 41, the concept note, doesn't map to these relatively sensible definitions. As we see in documents like the concept note, sex and gender are ambiguously the same thing, but also somehow different. And gender is now effectively replacing sex entirely. Second problem, the definitions, while relatively sensible, are still fuzzy and open to exploitation with some plausible deniability. The definition of gender in the Rome Statute literally wouldn't have been agreed to and adopted by the diverse states if it had not been an effective example of constructive ambiguity. So WGI has asked the committee, the CEDAW committee, to reject the term gender stereotypes and return to the language of sex stereotypes or sex role stereotypes as written in the convention itself and agreed to by the 189 member states. The convention, CEDAW, uses the language of sex 3 times in its text. Firstly, the preamble declares that all humans are born free and equal in dignity and rights without distinction, quote, based on sex. Article 1 defines discrimination as any distinction, exclusion, or restriction made on the basis of sex. And Article 5 is named sex role stereotyping in the Convention's own table of contents. The text of Part A of this article clarifies the meaning. It puts an obligation on states to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes or on stereotyped roles for men and women. These social and cultural patterns described in Article 5 are what are termed gender in the Rome Statute. It's therefore an ambiguous misnomer to refer to gender stereotypes, as gender itself is the agreed term for those stereotypes. Sex role stereotypes, as described in Article 5, are what the general recommendation seems mostly to be directed at, however. They're just not calling it that. Paragraph 15 of the concept note says that the CEDAW committee to date has not defined gender stereotypes. It says, according to renowned scholars and the Office of the UN High Commissioner for Human Rights, the term gender stereotypes refers to a generalized view, belief, or preconception of attributes or characteristics that are or ought to be possessed by, or the roles that are or should be performed by men and women. The reference to men and women here is clear, as is the implied division between the underlying quality, maleness or femaleness, and the social construction or expectation layered on top of that quality. Paragraph 27 notes that both the CEDAW Committee and the Committee on the Rights of the Child have emphasised the deeply rooted nature of harmful practices, attributing their existence to prevailing social attitudes that view women and girls as inferior to men and boys based on stereotyped roles. The multi-dimensional causes of these harmful practices encompass, they say, stereotyped sex and gender-based roles, and perceived superiority or inferiority of both sexes, among other reasons. So the reference to both sexes here refutes the ideology of non-binary sex and actually contradicts recent judicial commentary and legislative amendment in countries like Australia that there are not only two sexes, where references, for example, to the opposite sex were replaced in the Australian Sex Discrimination Act with the phrase a different sex. And this change was noted by the Parliament to be specifically in reference to there being more than only two sexes. So member states to CEDAW are already going further than the language of the UN instruments. The general recommendation, even in clause 33, gives a sex role example, saying, for instance, this can occur, discrimination, through a constitutional provision that reinforces stereotypes of women as caregivers and homemakers, a judicial ruling not grounded in law or fact, but rather on sexual stereotypes related to rape, or school textbooks that expressly reinforce sex role stereotypes concerning appropriate occupations for men and women. So, why is GR 41 using the term gender almost exclusively if the convention to which it relates only uses the word sex, if the use of the word gender is circular, and the recommendation itself seems to intend the meaning of sex role stereotypes? It seems to be some combination of catering to ideological demands and perhaps not thinking carefully enough about the consequences. So gender, as noted expressly and favourably by member states in discussions of its use, is a highly elastic term that allows states a lot of latitude in its application. Sex, on the other hand, as we know, is not. It is a quality that can be observed in material reality, and it remains consistent across time and culture. Because of its elasticity, states can use the term gender in law and policy to avoid granting protection on the basis of sex, and instead to privilege the gender stereotype with which an individual identifies. This reifies and protects the oppressive stereotype, not the material sexed body underneath. Women are oppressed on the basis of this body, by the very stereotypes being protected by the word gender. As the WGI Declaration says, the concept of gender identity makes socially constructed stereotypes which organise and maintain women's inequality into essential and innate conditions, thereby undermining women's sex-based rights. Because of the added layer of the United Nations' own conflation of the terms sex and gender, member states are similarly interpreting and applying the word sex to actually mean gender, as in the socially constructed roles and stereotypes to which a person lends themselves or that they seek to occupy legally determines their sex. The recent matter of For Women Scotland and the Scottish ministers in the UK asked the question of whether a gender recognition certificate determines a person's sex for the purposes of the Equality Act. In other words, whether the Gender Recognition Act creates an interpretive obligation to read references to sex in law as actually meaning certificated sex rather than actual sex, biological sex. It asked the Supreme Court, when we say sex in law, do we really mean sex or do we really mean legal gender? Australia has addressed this same question and so far has answered it yes, but with no certificate even needed. In the 2024 case of Tickle and Giggle, the Federal Sex Discrimination Commissioner, I honestly, intervened to submit to the federal court the following. The Sex Discrimination Commissioner said, the Commissioner submits that the word sex is not a biological concept, referring to whether a person at birth had male or female physical traits, nor is it a binary concept limited to the male or female sex, and is also broad enough to encompass the idea that a person's sex can be changed. The Commissioner refuted the distinction pled by Giggle between sex and gender, that sex refers to biological features, while gender relates to the social context. So essentially, Giggle pled a version of the distinction claimed by many international documents and UN instruments such as the Rome Statute. This was rejected by the Australian Human Rights Commission and Sex Discrimination Commissioner, and sex was said to be determined by a person's expressed gender. The federal court ruled in favour of the Sex Discrimination Commissioner. The judgment of the federal court outlined the meaning of sex under the law. It said, first, sex is not confined to being a biological concept, referring to whether a person at birth had male or female physical traits, nor confined to being a binary concept limited to the male or female sex, but rather takes a broader ordinary meaning informed by its use, including in state and territory legislation. Part of this ordinary meaning and part of the legal recognition was the treatment and application of the terms sex and gender under international law, just like this. So Article 2 of CEDAW calls on all member states to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices which constitute discrimination against women. However, use by the committee of the term gender is one mechanism by which member states are undercutting their Article 2 mandate. It is the illogical and ideological employment of the term gender that is permitting this. On the 2nd of December last year, Reem Al-Salem, the UN Special Rapporteur on Violence Against Women and Girls, published an informal statement on X.com expressing her concern with this trend. She said, I am very concerned by the increasing onslaught on women-specific language, which seeks to erase the reality of womanhood itself and deny its innate and sex-related specificity. a number of influential media outlets, organizations, academic and health institutions, and experts are complicit in what can only be described as a new form of violence against women. It must be stated that words such as non-transgender women, cis women, and the like do not reflect any UN or otherwise internationally agreed standards. If the CEDAW committee endorses the term gender stereotypes in GR 41, it will further license this contemporary fad of ignoring the reality of the sexed body. It will undermine protections for girls and women on the basis of their sex, and it will unwittingly participate in the reification of the oppressive sex role stereotypes that the Rome Statute terms gender and that CEDAW and the general recommendation are supposedly committed to eliminating. So WDI has therefore asked that the committee use its 2025 deliberations to rename GR41 using the internationally agreed term sex role stereotypes, and it will submit further to the OHCHR February 17th discussion with the same request. There is an online submission form if any sister or organisation would like to do the same. The deadline is the 10th of February. Thanks very much, Jo.
How can we most effectively influence the CEDAW experts and other UN policymakers?
I wish I knew. I know that CEDAW experts are meant to be independent. They're not meant to be representatives of the states that they come from. But I do think, just as a human factor, if you do have a seat like Natasha Stott-Despoja is on the CEDAW committee, and she's from Australia. She's a former politician. I do think that you possibly have more ability to, speak the same language as a committee member from your state, if you do have one from your state. I think that for me, I don't know. I think that for me, one important thing is showing them how their implementation is undercutting their own mandate. You're meant to be doing this. This is what you want to achieve. This is the language of the aims. But by using this framing, look at the effect that you're having and showing the inconsistency between those things. So it's like the definition of sex is meant to be clear, but because of this increasing confusion, even the definition of sex is being undercut by member states. How, in this particular example, are the rights of women being protected? Like, how is that mandate being fulfilled? But I'm a very kind of like, I'm very give me the facts, show me the logic of it person. It's not necessarily going to work for everyone. Like I know, is it Bandana Rana? She's heading up the sub kind of committee looking at GR 41, and I just don't get the impression from a lot of her communications and her Facebook page and stuff that that's how she approaches it necessarily. She seems to be more interpersonal, kind of social. So it's hard to say. But I do think we have so many cases nowadays from around the world where the rights of women have been undercut because of this problem, and they are empirical evidence that the mandate is not being fulfilled. And a lot of the time, it can be connected to the language that is used in the law, which is connected to, we can see, to the language that is used in the international instruments, whether or not they're binding law in your country, because I know that different countries, international treaties don't all have the same legal status. Like in Australia, they're not law, for example. But America, one of the reasons America won't sign a lot of things is because they are, so I think it depends on your country as well.